All right. Well, good afternoon. We are on the record in State of Indiana versus Richard Allen, 08C01-2210 Mr. 1. I'll show that Mr. Allen's here in person with his attorneys, Mr. Rozzi and Ms. Auger. I understand Mr. Baldwin is tied up in another matter and won't be able to join us. The state is here by the prosecutor, Mr. McClelland, and Deputy Prosecutor, Ms. Diener. Thank you for making yourselves available for our hearing. I know it was kind of short notice, I know everybody's really busy, but I know that we had an issue that we kind of left hanging at the end of our hearing, and I appreciate, 1, that we had the forethought to schedule this hearing and, 2, that we weren't trying to do it at 7 o'clock at night on the last day of our hearing. I know, when we were up here at the bench, everybody was very tired and it was an extraordinarily long day that last day, as well as the 2 days prior, so I appreciate that we all had the opportunity to get some rest and then reconvene. So I also appreciate our agreement that this portion of our hearing is closed to the public. I know we have members of Mr. McClelland's staff and members of Mr. Rozzi's staff, but this hearing is closed to the public and to the media. ND, I think that's appropriate based on the nature of the discussions. I know that we were having discussions up here at the bench and it's really hard to do that and have any kind of privacy with 1,000 people in the courtroom, so I appreciate that we had this opportunity. Mr. Allen, at the conclusion of our hearings on July 30th through August 1st, I did have some concerns that I shared with counsel up here at the bench. Those concerns were about a statement that you had made to Dr. Walla. You're aware that your attorneys filed a motion to suppress the statements that were made. I think that motion was filed April 11th of this year. Attached to that motion were reports that were provided by Mr. Rozzi to the court from the Department of Correction. I know there were reports by Dr. Walla, there were reports from other inmate guards, reports from, the warden. I think there was a comment in there from the warden, and on page 84 of the motion is the report that caused me a little bit of concern. That was the report from Dr. Walla. It covered an interaction that she had with you June 11th of 2023. I know, in that interaction, I believe I've given that information to counsel in an email. The specific area that caused me my C1 concern, you expressed some frustration, and Dr. Walla quoted you in that report indicating, he felt his attorneys were not listening to what he wanted, such as him wanting to just plead guilty. So I told the attorneys up here at the bench, Mr. Allen, that this statement caused me some concern. The attorneys are very well aware that the decision to plead guilty rests entirely with the defendant, with yourself. It's akin or similar to a decision to testify at a trial, that is only your decision. It is similar to a decision that you would make as to whether or not you want to have a jury trial or a bench trial. Those are decisions that are made by yourself with the advice of counsel, but that's your decision to make. So your attorneys have a duty to carry out your wishes, so if you tell them that you wish to plead guilty, they have an obligation to help make that happen, and that's what I shared with everybody up here at the bench. I know Mr. Luttrell isn't here, but he was up here at the bench, as was Amar Baldwin, as well. So I shared those concerns. I asked the state, at that point, if a plea agreement had been offered to you. The state initially indicated that it had not made an offer to you, but then Mr. McClelland indicated that he had made an offer. I believe it was Mr. Rozzi told me that it wasn't an offer. I think you referred to it as an angry email, and Mr. McClelland stepped in and indicated, no, it was an offer, so the state again indicated that that was an offer. Are you aware, Mr. Allen, that an offer had been extended to you?
As of today, I am.
As of today you are, okay. So you weren't aware of that prior?
No.
Okay. So, Mr. McClelland, I asked if you would, please, prepare that offer and, if you have that offer, I'd like you to read that into the record and provide a copy of that to Mr. Allen and to his attorneys here in open court.
Yes, Judge. The offer the state made via email, it wasn't a formal offer in writing, but it was through an email, is that the defendant agrees to plead guilty to the information charged in counts 1 and 2 of murder, that the sentence is left to the court in its entirety, and that, if the court deems probation is appropriate, the terms and conditions of probation be left to the court, that the defendant will have no contact with the victim's family, that all fines, fees, and costs be left to the court as deemed appropriate. The state will agree to dismiss all remaining counts.
Has that been reduced for a formal offer, written offer, to the defendant?
Yes, Your Honor. I brought it with me today in court. Do you want me to give the court a copy as well?
No. I don't need a copy. I want to make sure that Mr. Allen has a copy of that and that his attorneys have an actual, formal offer other than an email, but I understand an offer is an offer in whatever shape or form that it is tendered, so thank you for providing that to counsel and to Mr. Allen. So, Mr. Allen, you now have received the state's offer. Do you wish to plead guilty?
No, Your Honor.
Okay. So you wish to proceed with trial?
Yes, Your Honor.
Okay. I would, then, ask that we recess this hearing, so that we can invite the public in, if they wish, because there's only a couple of logistical matters that we need to discuss on the record about the upcoming trial and the court's availability prior to trial. Mr. Rozzi, did you wish to make any comments or say anything or add to this record?
Yeah, I have a really kind of a question. I, of course, thought about the context of all this, and I certainly don't want to see a situation where, if Mr. Allen is convicted and there's an appeal, that somehow somebody comes in and says, well, wait a minute, his lawyers were ineffective, they didn't communicate an offer to him. And I'm thinking that that's important to the court as well. I'm not trying to, suggest that that's why we're here today, but that would make sense. Mr. Allen indicated that, as of today, he was aware of that, and I'm just reporting to the court that I shared this email with him. It was probably a week or two ago now. I've lost track of time, but it was since we were last here.
Okay.
I shared this email that I have from Mr. McClelland, the one that I referenced previously at the bench, with him, let him read it, and he acknowledged that it existed, and so that's kind of the backstory of how he became familiar with this email. I don't want to get into a bunch of arguments today, but we are making a record. I didn't view this as a formal offer. I viewed it as two lawyers who were, exchanging blows over emails about an issue that was, actually, it was about an issue of your recusal is how it started, 'cause there was a motion filed around that time. This email is dated January 30th of 2024. It's not, it's 8 months after the circumstance that you wanted to address today, so I'm just trying to clear the record on that. And the offer that was made in the email was one of, well, basic all why. If your guy wants to plead guilty, this'll be over. He can plead guilty to 2 counts and I'll dismiss the other ones. Well, at that time, actually, there were only 2 counts. The state had filed a motion to amend the information Abu T 2 weeks prior to this. I think sometime around that hearing we had in front of the Supreme Court in January, and Your Honor didn't even address the amended charges I think until March. If you look at the CCS, you'll see those dates. But I guess my point being is that the banter that was going back and forth was also about counts that hadn't even been formally accepted as part of the charging information. And I just want the court to have some context in how all this kind of unfolded, and that's the backdrop.
Okay.
Yeah.
Ms. Auger, did you wish to speak?
No, thank you.
Mr. McClelland or Ms. Diener?
I don't have anything on that topic, Judge. No. I do have a few other things I'd like to address with the court in the closed session. But on the topic of the plea.
Okay.
It's been presented. If he doesn't want to accept or plead guilty, then the conversation's over and we'll move on.
Okay. And my experience with prosecutors up in my jurisdiction is they put time limits on extended formal offers, like 7 days prior to trial the offer expires, 5 days prior to trial the offer expires. So I don't know what your practice is here in Carroll County.
It varies, Judge.
Okay.
I would say the offer's expired at this point. If Mr. Allen does want to plead guilty at some point, the door's always open to talk about.
Okay.
An offer, a negotiated offer, I never closed that door, Judge. If the court will accept an offer at the last minute and we can work something out, the state have done that on occasion as well, but at this point I'd say the offer's closed. He doesn't want to plead guilty. If we need to come back to the negotiation table, we can do that.
Okay. That's fine. All right. What else did you want to discuss, then?
Judge, I don't know, in most cases I wouldn't even bring this up to the court. But given the nature of this case, I want to talk to the court about it. What I'd like to be able to do is show the families some of the crime scene photos and some of the photos we plan to introduce as evidence before the trial to mentally and emotionally prepare them for those, in case they see them at trial. Again, typically I wouldn't address this with the court, but given the nature of this case, I wanted to get the okay from the court to be able to do that. I haven't done that to date.
No objection.
I'd have no issue with that. Candidly, I think that's probably good trial prep for family members. Perhaps the same could be held for Mr. Allen's family. I know, during the course of the hearing, everybody was being very careful about displaying those to the court, but I know that there was, you can't see it, because you're facing me, but I'm looking out to the audience and there was a lot of emotion from both sides of the courtroom, specifically with Mr. Allen's family to my far left and the victims' families over here to my right, so I think that would probably be a good idea.
You go ahead.
While we're on the topic, I would appreciate the court allowing us to address those with Kathy Allen and Janice Allen, his mother and his wife. Those would be the two people that I think we would disclose that to.
Yeah.
So we'd ask for the same.
Absolutely.
Just wanted to make sure. I want to name those people for the record. Thank you.
The other topic, Judge, I thought was appropriate to address in the closed session is, whether or not the court was still planning on sequestering the jury, and then, for my scheduling purposes, whether the court planned to have the trial Monday through Saturday and even on the holidays that are going to fall within that 30 or 31 day range. And so my question to the court was the court still planning on sequestering the jury for the full amount of the trial, and was the court schedule still going to be the Monday through Saturday and even on the holidays? I think there may be 1 or 2 holidays within that month, but I could be wrong.
I don't. What holidays are they?
I think there's Columbus Day and maybe Veterans Day. Columbus Day may be the first day we're planning on starting, actually, Judge.
It is, up in Allen County, yeah.
There's also Election Day.
Oh yes.
So that might be problematic to have.
I know that
I want to make sure everyone has a chance to
vote. And I know that.
Oh, I'm sorry, I didn't mean to interrupt. I'm sorry.
No, I know that when we scheduled the trial, the clerk of the court immediately reached out that the election polling place is downstairs in the basement, and there was tremendous concern from her and the Department of Homeland Security director about that, and I said, I don't know what to tell you. You'll have to find a different place to have voters go. But sequestering the jury, yes. We've already made arrangements for the jury's hotel, similar to what we had made arrangements before in May. I had anticipated going Monday through Saturday, at least through till noon on Saturday. That gives, you guys need a break, you know. I was a trial attorney for 15 years, trial work is hard. Attorneys need a break. Mr. Allen needs a break. Your witnesses need to be kind of juggled and massaged a little bit. So my thought would be that we would work until noon on Saturdays. And as far as holidays are concerned, we're starting the trial on a holiday. We'll have to figure out Election Day, so thank you, Ms. Auger, for bringing that up. We'll have to figure out Election Day, but I have no intention of not working on holidays, unless something comes up. I mean, trials are fluid, we all know that.
What hours are we talking about?
I was thinking 9 to 5. That gives everybody the chance, because I know Mr. Baldwin and Ms. Auger are out of town. You're out of town, but you're closer.
Yeah.
I'm not sure about Ms. Diener and Mr. Luttrell. I know Mr. McClellan's local. But regardless, I think 9 o'clock is a good time to start. That way, Mr. Allen can be awakened and get breakfast and get dressed to be presented into court.
That will include jury selection days that are in Allen County, right?
Yes. The jury packets have gone out and they're starting to trickle back in, and much like we had discussed before, we would start round 1 at 9 o'clock and we would start round 2 at about 1:30. It takes, and they'll be coming in groups of 50. Now, that may not be 50 actual humans, it may, we're splitting the venire into the packets that we gave you before. It's not the same people, but the same groupings as before, so that we would have 100 people on each day, anticipating that we would probably be done Wednesday, I would think.
And then Thursday would still be a travel day and start testimony.
Yes.
On that Friday.
And start testimony on Friday. Prelims.
Sorry, Judge.
No, and that's kind of good that we are having this discussion. I hate having these discussions in front of company, because it kind of interrupts flow of thought, but yes, that would be my intent.
And just so I'm clear, the plan is sequester the jury the whole time, even on the Saturday afternoon and Sundays?
Oh, yes, yes.
Okay.
I'm not sending these folks home, not after you've spent days picking them.
Sure.
And I don't want them exposed to anything. We've made arrangements with the hotel to remove televisions and phones and radios and, so I have a whole agenda that I've used. This is probably my 5th or 6th sequestered jury.
Okay. Very well, Judge. So Friday at 9 is when we'd be expected to make opening statements, I supposed would be the day.
Yes.
Okay.
Yes.
Thank you, Judge.
Your Honor, it may not be my place to say, but we should probably figure out what we're gonna do with, wait, if the jury's sequestered, how, are they going to be bussed back to vote or will they be given the opportunity, how are we gonna handle that?
Bussed where?
Well, to Allen, they're Allen County voters, right?
Yes.
So.
We will transport them here. I've already made arrangements for transportation and everything.
When is Election Day? Like the first Tuesday of November or something? I'm just trying to.
November 5th.
Okay.
Yeah.
All right. So we won't be taking that entire day off, because we're trying to accommodate the jurors voting, or will we? Maybe I just misunderstood what.
No. My hope is that everybody's already coped by then.
Oh, okay.
That we will have, I think part of my initial conversation with each panel, each round, is going to be, once you get selected, we have early voting in Allen County.
Sure.
And there are like 5 voting centers. My conversation with them after they've been selected will be to include, and I'll give them a written form, as well, to include, if you wish to vote, you need to do that prior to us leaving, because I can't bring you back here on November 5th to vote. So.
Thank you. Sorry, I don't mean to beat that horse, but.
No, I mean, voting is important, it's.
Yeah.
It's very important. So anything else from the state, Mr. McClelland? Any other topics to discuss?
No, Judge. I think that covers everything I wanted to cover with the court. Thank you.
Okay. Mr. Rossi, anything that we need to cover?
No, ma'am, no.
Okay. Is there a need, then, to go into open session?
You know, there were some filings this morning. I don't expect that you necessarily would have seen them. You were maybe in transit. They're just some discovery-related issues.
I saw them.
I trust the court can handle them in the normal course. If you want to address some of those things now, we're here, I'm willing to do that.
Go ahead.
I'm okay with however you want to handle it. I just noticed that.
Well, you're asking for information, basically, from state, the DOC, and the Attorney General.
Yeah. I filed 2 motions basically asking to shorten the time frame on a request for Dr. Walla's employment file.
Uh-huh.
And then a request for any DOC investigative materials associated with her employment. And then, the state filed a motion to quash some or some depositions that are scheduled next week of Patrick Westfall. Mike Westfall?
Nick.
Nick, sorry, and of former Sheriff Leesenby, Chief Deputy Leesenby. So those are the 2 filings, or I guess 3 technically, that are on the record.
I think they're on the motion to suppress.
Oh, they did? I didn't see that.
Quash.
Oh, the motion to quash?
I have not seen the motion to quash.
Yeah, it's not done.
Oh, okay, that's why.
So, I'll just speak to the Wallace stuff. It seems discoverable to be. I have, reason to believe there's maybe even some changes in her employment. I did try to reach out, as a courtesy, to the DOC staff attorney and TE Attorney General and just ask the questions, and their response was, "You're gonna have to send formal discovery requests." So, and that's what I expected them to say, so I was just trying to follow up with that. And I did reach out to Ms. DeEner and asked her if she would waive the 15 days, or if the state would waive the 15 days on one of the requests, and they declined. And so I'm just seeking to shorten the time frame. I don't really want to make a bigger deal out of it than it is. That's what it is.
Okay. What's the state's position?
I don't know, Judge, I haven't considered it.
Okay, all right.
At this point, and so I don't really have a good, formal response for the court. I don't know that there's any valid objection to her employment record. The other one, I think, was, and I didn't get a chance to review it before court, but they had some disciplinary complaints perhaps, or internal affairs investigations, I believe, but I didn't look at it at length, Judge, so I'm not really in a good position to be able to respond intelligently about that.
All right. Then, get familiar with it and get me a response.
Yes, Judge.
And then, again, I have not seen the motion to quash. You have not seen the motion to quash, so we'll have to. Can we agree that I can just rule on these things?
Yeah.
Yes, Judge.
Okay.
I think the backdrop of all this is that we've been working together, the state and the defense, to get the rest of the depositions scheduled, and that has included us sending the people we wanted to depose to the state a few weeks ago, on the back end of our hearings we had, and then them saying, "Here's our reaction to that, Nick's available on one day, Stacy's available on another, Jim's available on another, and Stacy needs to handle this witness, Nick needs to." And so we actually spent a considerable amount of time together trying to accommodate all that, and we ended up sending them a schedule like, "These are all the people, these are the dates based on all of our communications." And there were a few of THEM that we just couldn't find a middle ground on, and so I just suggested to the state that, "Look, here are the dates. The 2 or 3 that we couldn't find a middle ground on, we're gonna schedule them on the dates we want to do them, and then we'll kind of deal with the fallout. Because there's just too many moving parts. There's nothing going on any more than us just having a very short period of time and trying to schedule 15 or 20 depots, and I think there was 2 or 3 of them they were hoping we would hold off on until you issued some rulings on the third-party stuff. And I just said, "Look, we gotta schedule them, and then we'll kind of deal with the fallout. Because there's too many moving parts."
Right.
So that's really what it amounts to, or at least in my eyes.
All right. Is there anything else from the state?
No, Your Honor.
No.
Anything else from the defense?
No, ma'am.
So no reason to go into the open session, since we've had this conversation? And again, I appreciate the opportunity to have some conversations without everybody sitting out there staring.
You not go out there and tell them that we're not doing anything on the record? 'Cause I'm not.
I'm gonna recess and we're going. How's that? I figured that I would be on the road longer than our hearing, but, we needed to have this conversation, and honestly, I'd rather have it today than try to have it on August 1st at 7 o'clock at night, when everybody was tired and tempers were getting short and people were getting hangry and everything else.
Oh yeah.
And, clearly, Mr. Allen was tired.
I anticipate, once you issue some rulings, I think, and this is just kind of what we're talking about as a unit, the defense, that we're gonna file some kind of a notice with the court about how much time we think we need in much more detail, so that the court has some idea from us. Okay, this is how we perceive how long it's gonna take us to present our case. I'm assuming you want that, after we've kind of been through this other, the Maze situation.
Sure.
So I'm just letting you know that's what our plan was.
Okay.
If the court wanted to do that in another hearing like this, as opposed to us filing something that kind of lays out our anticipated time frames, that's fine with us too, but I don't. That's how we discussed handling it.
You can file something. I mean, and if you're concerned about it being work product, you can certainly file it as a confidential pleading.
Yeah.
That's then available to the state, so you're aware, as well, but the public isn't going to have access to it.
Right.
I'm fine with that.
Well, that's kind of what we were thinking. I don't, we can't really control what they're doing, obviously.
No. I mean, and just so you know, when we start voir dire, it's gonna be kind of cumbersome for both sides, because you're gonna have to do it twice every day.
Yeah.
So the first time, I'm gonna ask you, I will introduce you, just since we're here, I'll tell you how I do voir dire. I'll introduce you. I have, Rule 14 says I have to introduce the case, and I'll ask you to list your witnesses so that people will know, and I know that those names have been already included in the questionnaire, but there's a lot more witnesses that aren't in that questionnaire that I'm sure that you're going to want to have. And I don't expect that any of Allen County jurors are going to know any of these people, since they're not from around here. I'm pretty liberal with time. It's usually, on a murder case, I'll go an hour around 4, per side, just so that you're aware. And the bailiffs will have seating charts for you that will be fresh every round, so you'll have the 50 people with this seating chart, the 50 people with that seating chart. And I won't sequester them upon selection, we will tell them to come back on Thursday to be prepared to be bussed down here to Delphi.
Okay.
Okay? All right.
Judge, one other thing.
Yes, sir?
It made me think of something when you said about if the defense is going to file something confidentially so that the state can see it, and I appreciate that. One of the reoccurring problems that the state gets notice of weekly is the continued leaks about the case and discovery being leaked and those kind of things, and I think part of the problem is that we've got several attorneys still on the case as attorney of record. Kara Wienick, Mr. Osbrook, there's media, Hennessy. Are these attorneys still necessary? Do they still need to be involved in the case, have access to the case? The attorneys for media groups are still there. And so filing confidentially, basically, it just goes to all those attorneys and it gets broadcast to the world anyways. So I guess my question is, do those attorneys need to be attorney of record on the case when I don't see that they have any further function in the case?
I don't think they have any function on the case. I know Kara Wienick filed a limited appearance, but I don't know that a limited appearance shows as a withdrawal at the conclusion, because the clerk doesn't know. I'm happy to do an order striking all of the extraneous. There's 6 lawyers that need to know what's going on, the 4 of you that are here and the 2 that aren't here.
Yeah, I agree with that.
Those are the lawyers that need to know, so I'm happy to do an order directing the clerk to remove them as attorneys of record. If they don't say the 6 names that I know that are, then they're out. And that's a good point. Thank you for bringing that up.
I don't know. Can you do that with the media? Do they have a right to have a limited appearance in?
Well, it was the media attorneys, because remember, at the beginning of the hearing, they filed motions to intervene because they wanted the public access to the charging information and the affidavit for probable cause. They filed a motion to intervene, but with that motion came their appearance, and they're still, I assume, listed as attorneys on the case.
I think there's like 15 attorneys on the case.
Yeah. I don't have a problem with you striking them as long as Mr. Baldwin, Ms. Auger, and myself are part of.
And, Judge, they can always refile their motion to intervene.
Yeah.
If they think there's a necessity for them to make another filing, and so it's not blocking them from doing that, It's just taking them off because the reason they entered their appearance in my mind is concluded.
Oh, it concluded 2 years ago.
Correct.
Are Screamin' and Labrato still getting notice?
Yeah, they are.
They're still on there because when I looked at the most recent item that I got discovery of, I could see Wienik.
Okay. Yeah, I'm fine with all that.
Osbrook.
No objection.
All the attorneys and Wienik, okay, and Screamin' and Labrato. All right.
And Screamin' and Labrato. Yeah, I think they're still getting notices.
I will do an order when I get back directing the clerk to remove all of those individuals as attorneys so that we don't have that problem and it's just the 6 of you.
Thank you.
I don't have anything else, Judge, so thank you for accommodating that request.
Oh, sure. Anything else from the defense?
No.
No, ma'am.
Oka, why? Before we recess, I did want to let you know that the 2 weeks, I don't have a, oh here we go, thank you. Okay. I just wanted to advise you of my avail, thank you, Jody, my availability. I'm at Judicial Conference September 17th through the 20th, so
Okay.
I think it's in Indianapolis that week, so I'm not available that week.
September 17th through the 20th?
September 17th through the 20th. And then, I am out of the office on a holiday October 1st through the 10th.
That's probably a really good idea.
I'm sorry?
That's probably a really good idea.
Well, I had this scheduled when ended up canceling, well, when we set the trial in May.
Oh.
I was like, oh, 'cause those were weeks that we had set for October's trial. I was like, oh, I can take those weeks now. So
Well, I'm just opining that there could be a circumstance where we need the court's intervention or quickly, what would the court? I don't want you to, not go on vacation.
Yes.
But are you gonna be available on kind of an emergency basis?
Yes.
Okay. Yeah.
And you have my email, and my email I think will work where I'm going.
Okay. That's a shame.
If it doesn't work.
That's a shame.
I know.
Yeah.
It is what it is.
All right. Very good. Okay.
Okay.
I could just see something coming up.
Well, and something always comes up at the last minute.
Yeah, right.
But that's why I'm back in town the 9th or the 10th.
Yeah. Okay, very good.
All right. Thank you.
Thank you.